We are back in court for the trial against Donna Adelson, but at the end of the day on Friday, the prosecution rested. So we are now in the defense case. But of course, on Friday, the judge was like, hey, are we making the motions that need to be made at the end of trial? You know, the judgment of acquittal or motion to dismiss, whatever you want to call it. The motion where the defense says, hey, we don't think there's enough evidence for a jury to find our client guilty. And the defense was like, I thought we were doing that on Tuesday. So the court was like, fine. And then the court said, how long will the defense case be? And the defense said, can we tell you on Tuesday? And the court said, fine. So now it's Tuesday. In pretrial motions, the prosecution said their case would be 5 to 7 days. They ran for 6 days. The defense said that they would be 3 to 4 days. I don't know what they're going to do for 3 to 4 days, but we'll see because they have not filed a witness list. So we'll hear about that, I expect, this morning. We are on trial day 7. That is counting starting with opening statements. But they had 4 days of jury selection. So we're really at the beginning of week 3. The court said 3 weeks. That's it. No more. The court wants to be done with this case by Friday. The defense is going to have to zoom through this case. I don't think they got 3 to 4 days of witnesses. I got to be honest. I guess we'll see, won't we?
We're here for principal to first degree murder, conspiracy, and solicitation. Venting about how somebody's treating their daughter is not the same as asking somebody to have them killed. Focusing on what evidence exists as to my client's statements and actions prior to the murder actually happening. According to Williams, judgment of acquittal is appropriate on count 1.
Concerning Williams specifically, was there evidence of consciousness of guilt admitted against the defendant in the same way it's been in this trial?
In Williams?
Yes.
I don't believe so.
So in addition to any circumstantial evidence, any inference, we also have in this record the defendant allegedly making a confession, suborning perjury, and attempting to flee.
All of those, the after the fact things, yes, it might be relevant to consciousness of guilt. However, it doesn't overcome the absence of evidence as to what Donna Adelson did on July 18th of 2014. That's what Williams speaks to.
Right, the legal standard the court must apply at this point is reviewing the evidence in the light most favorable to the state. I believe in Turner versus State 29 Southern 3rd 361. In moving for a judgment of acquittal, a defendant admits the facts and evidence in every conclusion favorable to the state that may be reasonably inferred from the evidence. As to the direct evidence, the circumstantial evidence, and also the consciousness of guilt evidence taken together, I believe this is sufficient to overcome the matter that was raised in Williams versus State. The motion for judgment of acquittal will be denied at this time.
I want to talk to you, I'll lead you forward to the date that Danny Markel was murdered. That was July the 18th of 2014. Do you recall speaking to Mrs. Adelson on that date?
Yes, I do.
Okay, and can you explain to us how you were contacted and the nature of the conversation?
I was called, and Donna was quite hysterical.
Okay.
And she said to me, Danny's been shot.
Sustained. Do not speak to what anyone said out of court, ma'am.
Your Honor.
Please continue.
May we approach, please?
Please approach.
Thank you, Judge. Before we talk about what she might have said to you, at the time that you spoke to Mrs. Adelson, was it the day that Danny was murdered?
When he was shot, yes.
Okay. And yeah, I use murdered because obviously he didn't pass away until the next day, but
yes,
he was shot and barely surviving on the 18th. So that's when I refer to that. That's why I say that
yes.
date. Okay. So when you spoke to her, did she call you or did you call her? Do you recall?
She called me.
Okay. And when she called you, did she appear to be upset?
Very.
Was she crying?
Yes.
Was her tone of voice, based on your knowledge of her for the 15 years, did she seem to be upset?
Very.
Okay. Did she seem to be at a point in time where she had just learned what had occurred.
Yes.
Did she indicate to you whether she had just learned that this had happened?
Yes.
Okay.
She did.
I'm sorry?
Yes, she did.
Okay. And during the course of your discussion with her about what had transpired, did she continue with this state of mind that she was upset?
Yes.
Okay. And while she was upset, what did she indicate to you?
She told me that Danny had been shot and that they were going to Tallahassee and that she was very concerned and worried about Wendy and the boys, whether they were in danger.
Okay.
Because she did not know who had shot him.
Okay. And did she indicate whether she was concerned about Danny and him being in the hospital?
Absolutely.
Okay. Did she indicate whether she had plans to go to see him at the hospital?
I don't recall.
Okay. During the time that you had this conversation with her, was this the only time that you spoke to her that evening?
I believe so. Maybe one more time.
When you went through the process that you've already explained, manually going through the records, were you able to determine how many unique call events took place during this time between Donna and Charlie?
Unique. So for this one, I took the original file that I mentioned and I just looked at the filters between Charlie and Donna's phone number, and I was able to recreate the 80 when I just look at the totality of the data.
So you got the same number.
Taking a step back, all the way back to that slide 1, I mentioned that record for Donna contained data from 2014 through 2017. So that particular document covered both of the time frames. It covered this one, which is June 23 through July 22, 2014, and it covered what was in Charlie's records, which was May 2nd through July 20th. So I used that document that I showed you guys at the very beginning to dedupe. So I went through that document. I put the filters for Charlie and Donna's phone numbers, and then I went through each line during those time frames to determine, like, is this a voicemail activity? Is this just AT&T duplication? Is this an actual unique call event? So that was the document that I used, focusing on these two parties' phone numbers. And I went through each line by line, and removed manually any rows that I believed to be referencing the same call event. So when I did that, I got, for this time frame, deduplicated, and this would be attempted and connected, right? So it's including the voicemail. It's just noting that there's only one line for that voicemail, not potentially 3. I got 69 unique call events that would be connected and attempted.
So the failure to manually go through these records resulted in an overinflated report in these frequency reports.
That's their point.
Yes.
And in your review of the records, the call detail records that were provided to you, obtained by law enforcement, did Donna Adelson's handset ever connect to a tower that could provide coverage to Charlie Adelson's home on July 18th of 2014?
No.
And that's the point on the cell site. However, that's not exactly what the prosecution's map said. The prosecution's map showed Donna's handset connecting on the way towards Charlie's house, and then a text saying, "I'm outside," and then cell tower connection beyond Charlie's house and all the way up. So no, the prosecution did not show in their chart that Donna's phone connected to a tower that was also servicing the area of Charlie's house. It connected below and above. And then there was a text. I mean, that's not new information. It's just phrased a different way. And that's where the defense is going with that.
Those same records, was there any instance on July 18th of 2014 where Charlie Adelson's handset and Donna Adelson's handset were connecting to the same tower?
No.
Nothing further, Your Honor.
When you looked at Donna Adelson's records, was there a phone call between Donna Adelson and Annie Cunningham on the evening or night of July 18th, 2014?
I'm not familiar with that name.
You're not familiar with the name Annie Cunningham?
No.
Okay. What if I gave you her number? Would you be able to look and see?
I don't have the call details memorized, so
Do you have them with you?
the original documents I do.
Laptop, okay.
Yeah.
Would you be able to look and see?
I'm going to object this beyond the scope of direct.
Please approach.
So am I showing you a contact with Annie Cunningham?
Correct.
Okay, and you don't need to say the number out loud, but is there a number next to it that begins with 845?
Correct.
Okay, 845 being the area code?
Yes.
Okay, that's the number we're looking for.
Okay.
And my question was there a phone call between Donna Adelson and Annie Cunningham the evening PM on the 18th of July?
And to reiterate, it started with 845, correct? Okay, yeah. I see the number and I looked at the records for the evening of the 18th and I do not see a call to that number.
We are at the lunch break of day 7 of Donna Adelson's trial. The defense has gone through their first 3 witnesses. 2 of them were friends of the Adelson couple and 1 tech expert. The point of the tech expert was essentially that the prosecution expert did not deduplicate the phone records when looking at the call frequency. My takeaway from the call frequency evaluation was that Donna's most frequent contact was Charlie and then Harvey. And so if that is 5 duplicate messages or records, it wasn't really substantial. And she said, well, when I deduplicated the calls between Donna and Charlie, it was 69 instead of 80. It's not a massive difference to me. I think the defense made an excellent point. So I was surprised they were fighting with this, but I think the defense made an excellent point on cross-examination. And it stuck out to me because there were a lot of crosses where I'm like, you're doing what now? But this point resonated with me.
And so the amount of communications or attempted communications that are indicated during the June 2nd and June 4th, as you refer to it, flurry of communications, 7 is not a spike.
I do not consider it an abnormally high number of communications.
It's not like they didn't talk much or talked once a week or once every other week and all of a sudden they're on the phone 5 times a day. It's the behavior changes that law enforcement was really looking for. You're talking on the phone all the time, then all of a sudden you go to WhatsApp consistently. That's a change. If you're always talking on WhatsApp, fine. If a bank account's being overdrawn every 3 days and then all of a sudden there's cash for days, that's a different. If that account always has cash for days, that's not a change. So I'm not sure if the tech expert really accomplished much for them other than to muddy the waters, because now we're in the muddy water. The other point they tried to make was that Donna Adelson's phone did not connect to a cell tower that serviced Charlie Adelson's home. But what she did do was text, I'm outside. And then Charlie's return text was, I'm 10 minutes away. And then that return text hit a tower that was 10 minutes away from his home. So I don't think the defense made much headway by saying that Donna's phone didn't connect to a tower near Charlie's house when she was messaging him. But the water getting muddy is all the conversation about that friend, Ann Cunningham, and did Ann and Donna have a phone call that night? Because the phone records don't show that Ann and Donna had a call, which the prosecution would have known because they asked the tech expert, can you just clickety, clickety, clack, clack, and pull it up and tell me if there's a call between Donna and Ann July 18th, 2014 in the evening? No call. And then the defense said, well, was Donna's phone using data? Could that be consistent with using WhatsApp or Viber? Though counsel kept saying Viper, which actually sounds like a pretty cool name for an app. But as we get to the lunch break, the court asked, do we have a quick witness? And the defense said, no, we're trying to get Ann Cunningham back. She's coming back from the airport. So I guess they're going to ask her if they were on WhatsApp.
I have a question about your use of cell phone service, and we touched briefly on things like WhatsApp, and what was the other one you said you use?
Viber.
Okay, Viber. When you communicated with Mrs. Adelson, did you routinely use one of those apps?
Quite often, yes.
Which app did you use mostly?
WhatsApp or Viber.
Okay, all right. And as opposed to picking up and using the cell phone service, you would use those instead?
Yes.
Okay, I don't have anything further.
You spoke with her via regular phone call, June 23rd, July 20th and July 21st.
If it's on the record, yes.
But you're saying it was a WhatsApp or a Viber on the 18th.
Yes, they were in the car, and they often called on those apps in the car.
Would it surprise you to learn that WhatsApp didn't offer voice calls until March of 2015?
Then it was on Viber.
Must have been Viber, huh?
When you interviewed Miss Bird, did you tell Miss Bird that Mrs. Adelson was going to pay her for her testimony?
No.
Specifically, did you tell Miss Bird that Donna Adelson was going to buy her a piece of land?
No.
What about a trailer?
No.
What about veneers for her teeth?
No.
What about a small vehicle for her and her children?
No.
Okay. Did Miss Bird tell you that Mrs. Adelson had offered those items to her?
No.
That was the question I was curious about. Did Bird tell you Donna offered her that?
She was not a state witness at that time, right?
I wouldn't know.
Wouldn't know. Would it refresh your memory to see a copy of the state's amended discovery when we did list her as a witness?
I didn't see that. I would never seen that.
Okay, so that wouldn't help you to know when she was amended as a witness in the case.
I wouldn't have known it.
She doesn't know that.
So you were not asked to go there because she was a state's witness. I'll just put it that way.
No.
All right.
The prosecution's getting at, so the defense wanted you to interview her so that she could tell you Donna's story, the story that Donna gave her. So you were interviewing her so you could turn it over to the prosecution as a defense witness. Before Miss Bird was ever on the prosecution list, before the prosecution knew who Miss Bird was, the defense sent an investigator to go interview her. Why? Because Donna told her attorneys, my friend Patricia will say that Donna burned her friends in one way or another, and her friends came in and went, fuck that, let me tell you what the tea is.
Please report tomorrow at 8:30. We will resume at 8:45 with the witnesses. Please have all witnesses that will be testifying in the morning present and ready. Mr. Zellman, Ms. Fulford. Also, there is not to be any further violations of the rule of sequestration.
Yes, sir. That was certainly not intentional. And as I indicated, sidebar, one of our witnesses, I don't believe her flight gets in until 10. We will have further discussions with her to get her here as quickly as possible.
We're in recess.
Oh, the court is not happy. We are at the end of day 7. It is the first day of the defense case in chief, and they did go through 7 witnesses. I mean, it's 8 witnesses, but then it's kind of like 9 because witness number 1 was recalled as witness number 4. So a shorter day in court. The defense indicated that they do have witnesses for tomorrow, including one witness who won't be in Tallahassee until 10 a.m. Their flight lands at 10 a.m. Eastern, and the court's like, have all your witnesses that need to testify here in the morning. We are starting at 8:45, counsel. It is a short day in court. So tomorrow, the defense has some witnesses left for the morning, but when and if Donna Adelson is going to testify is the big question for me. I was hoping maybe at the end of the day today, we would hear the court ask Donna if she intends to testify, but the court's not going to do that until tomorrow. A lot of you are asking about Charlie. I don't think the defense is going to call Charlie. I think he is a rebuttal witness for the state, but we will see. Then again, I don't really know what the defense is doing with some of these witnesses. I'm like, okay, they're just throwing it against the wall to see what sticks at this point. And in their witnesses today, they brought in the investigators that interviewed the jailhouse informants to say, essentially, did the jailhouse informants tell you that Donna offered them money? No. What did they tell you? Oh, they told you that Katie McBanawa said, we extorted them real good. I mean, I'm paraphrasing. That's a choice. And then they called some character witnesses to testify about Donna being distraught after the murder. So I don't know if the defense moved the needle very far today, but it did seem to me that ahead of Donna's trial that was supposed to go in September, last year, 2024, that the first jailhouse informant, Patricia Byrd, had already spoken to the defense investigators. Also, Patricia Byrd reached out and was interviewed by the defense long before she was ever on a state's witness list. So she had talked to the defense investigators well before the state was ever aware of her or interviewed her, which goes back to, was Donna telling Patricia Byrd what to say? Hey, say that you were in custody with Katie McBanawa, and say that Katie McBanawa said, we had this great idea because we knew they had money like that, so we were going to extort them. Y'all know my thoughts about that. That's not how that logics. I can't picture a scenario where someone's like, you know what we're going to do? We're going to go commit a murder, and then we're going to extort somebody and see if they'll pay us. As Rivera testified to, you just do the robbery then, if they have cash sitting around like that. So again, the use of the word extort seems to be consistent with what's in Donna's script. And then the defense introduced the video where Donna and Drina, the jailhouse daughter that had the script, were sitting in the pod together, writing back and forth in notebooks. And at one point, it looks like Drina's drawing and Donna's writing, and they're talking to each other. Did the defense move the needle today? I don't know. Are they trying to find doubt wherever they can find doubt? I think so. And the defense at the beginning of the day argued their motion of judgment of acquittal, and that was swiftly and promptly denied. And then they ended court early because they ran out of witnesses for the day, and the judge was not pleased with that, especially after how packed the days have been. The court wants this trial done by Friday. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.